Good morning and welcome to the October 24th Maryland Public Service Commission administrative meeting. The first order of business is I will move to approve the minutes from the October 17th administrative meeting. Is there a second?
Second.
All in favor?
Aye.
Opposed? Hearing none, we will now move to our consent agenda. Madam Secretary.
There's one item on the consent agenda. The item is Quantum Telecommunications, Inc., filed on October 9, 2018, revised tariff pages, Maryland PSC tariff number 4, effective November 5th, 2018.
Do commissioners have any questions? Hearing none?
Yeah, I do. Staff's recommendation, is there a staff person? I understand that the rates were implemented in July, at the end of July, and your recommendation is to back date the approval. Is that right?
Correct. Margaret Tuberty on behalf of staff. The recommendation was to recommend that the company file revised tariff pages because the current ones that they submitted reflected a November effective date, but through communication with their representative, they said that the rates were effective July 31st in order to be in compliance with the FCC. So we would request a tariff on file that reflects that effective date, basically.
I guess, Mr. Chairman, my concern is, like backdating, filing a revised page with a back date. I think I would prefer to have the effective date be today and not be backdating, despite the fact that they were charging the rates. But just for consistency's sake, it makes me a little uncomfortable, Mr. Spivak, going, sort of approving, retroactively.
I understand the feeling, Commissioner. I do note that we have actually done this as a matter of routine. With respect to the CAF order filings, the telephone companies, the telecommunication companies have not always been great about getting their paperwork in on time to accomplish these changes, but they have been compelled to make the changes because that was the FCC's order.
Right.
So, in light of that, we took them when we got them, and we have fairly consistently dated them for the July 31st.
Oh, okay. So we've done this in the past.
Yes.
Okay. All right.
That's not
Well, if we've done it in the past, then I think we can we can do it again, I guess.
Okay, very
Done
good.
it before.
Great, then. If there are no other questions, is there a motion?
Yes, Mr. Chairman. I'd move that we accept the tariff revisions for filing and direct the company to file clean copies of the revised tariff pages with an effective date of July 31st, 2018.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion carries.
Thank you, Commissioner.
Madam Secretary, the administrative agenda.
The administrative agenda, the second item, is USERV filed on June 7, 2018, a waiver application under Section 10-404E.
Good morning, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This addresses a request by USERV Holdings, which is a transportation network carrier, TNC, where they've asked the Commission to grant USERV a waiver of the Public Utilities Article requirement to conduct fingerprint-based background checks of their drivers. The Commission's granted a similar waiver to two other TNCs, Lyft and Razier, in connection with the fingerprint requirement. USERV's proposed name-based third-party background check is similar to the background check that the Commission has approved again for Lyft and Razier. USERV asserts that the background check is as accurate and comprehensive as a background check that's based on a fingerprint data process. They rely on a contractor to do background checks of their drivers. Sterling, which is the contractor, is the same contractor that was used by Lyft at the time that Lyft applied for Commission waiver of the fingerprint requirement. USERV conducts driver record checks through another contractor, which verifies that the applicant's name is associated with the applicant's driver's license number. If the applicant passes the background check, USERV will require the driver to meet with their staff where the applicant's documents are reviewed, and there is a training session which deals with, among other issues, how to handle disabled passengers. In authorizing Lyft to utilize Sterling to conduct Lyft's background check, the The Commission required Lyft to comply with guidelines in addition to performing self-initiated regular inquiries into the criminal background history of their drivers. Commission required Lyft to comply with additional modifications in connection with the background check. As noted, the background check that Sterling would perform for USERV would be identical to the background check that Sterling performs for Lyft, which the Commission did approve. Consequently, the Commission recommends that the Commission grant USERV a waiver of the fingerprint-based background requirement.
Great, thank you. Commissioner O'Donnell.
Thank you, Mr. Chairman. I don't know why, but I'm having some discomfort with this item, so I want to ask some questions. When we did the Razor and Lyft authorizations, we had extensive contested hearings. They went on for some days, and now this just feels like since we've gone through those proceedings, we're just kind of rubber stamping this. It has that feel to me. And when we went through those proceedings, there were commitments made from the stand-in verbal testimony that we committed those companies to maintain those commitments. But yet we don't have that kind of cross-examination going on here. And actually, if I recall, staff recommended we do not approve those previous proceedings. So for a bunch of reasons, I suspect some discomfort here. If I recall properly, we tailored both of those approvals to those two companies, those two TNOs or TNCs, as a little bit different. They were similar, but they weren't exactly the same. There were different conditions because the companies had somewhat different business practices. You say this one is similar. How is it different?
Good morning, Commissioners. Regina Gee with staff. The main difference that user has is that they also, in addition to providing the same identical background provider as Sterling that Lyft used with Sterling, they do the same face-to-face meetings, but they also have a safety program where they have a training program where they meet the drivers again for a 4-hour training program. So they actually go a little above and beyond what was approved for Lyft.
So I see in our packet we have a significant record built on data requests and questions that staff has asked the company. Should we condition our approval on this to hold them accountable to the commitments or the assertions made in those data requests as well, kind of like we did in the proceedings we had here for Razor and Lyft?
Well, that is what staff's intention would be, that it would be the same conditions that were approved in the waiver order.
No, I'm not asking you that, though. I'm asking you something different. I'm asking you, should we hold them to the conditions or to the assertions they made in their responses to the data requests?
Yes, we should.
Okay, because I don't think that our proposed recommendation says that, and I wanted to clarify that. And I guess the company's here. I'd be glad to ask the company some questions, too. I had one more question for staff. It says that we authorized USERV to operate on October 1st. Is that accurate?
Well, we approved them as a carrier. The first condition would be they have to be approved as a carrier before they can even put in for a waiver request.
Got it. So my memory is often faulty, so I had to go back and check my calendar. October 1st, we were doing rate case hearings for, we were in another proceeding. Did we do it on a previous AM or remind me?
Oh, no. The approval for the company is just through the Transportation Division, the normal process is that we approve any other carrier.
I was reading the staff authorized, or the commission authorized, and I'm thinking that's an action we took that I didn't recollect.
An order comes downstairs and it's signed off by the Executive Secretary's office.
Okay, all right, fair enough, fair enough. Might I ask, excuse me.
I was just going to go ahead and recognize the company. If you'd like to step to the microphone and introduce yourselves, then Commissioner O'Donnell has a question.
Good morning, Commissioners. I am Trish Fitzpatrick, Vice President of Corporate Outreach for USERV.
Good morning, Commissioners, and thank you for your time. My name is Mark Adler. I'm the Corporate Counsel for USERV.
Okay, thank you for being here.
So, first, can you tell me a little bit about USERV, your history, who your company is, what your service area, where you operate, who are you?
So USERV is actually what we call an adaptive transportation network company. That is, we are a transportation network company as defined by the law in Maryland. We, however, focus on rides for the disabled, for the elderly, and for non-emergency medical transportation. We are headquartered in Richmond, Virginia, where we started operations in May of 2016. And we have a contract, our first contract, supplying these kinds of rides was with Greater Richmond Transit Company, GRTC. We have had that contract extended. It's now over a year that we've been providing those rides for the disabled and for the elderly in Richmond, Virginia, and Henrico County. We've done probably over 10,000 rides since we started. We also are licensed and operate in Tennessee. We have a contract there in Nashville for the Metropolitan Transit Authority, which was just extended to a multi-year contract, and we're very proud to say that that multi-year contract is 3 years with 5 one-year extensions. And that's a testimony to the success that we had with the pilot program down there. Basically, we also have a license in the state of Florida, and hopefully we now have a license in Maryland, and hopefully we will get this waiver so that we can start operating. We have a contract that we are hoping to begin operations at Frederick Hospital to supply transportation for clients of the hospital that need special care. And our service, differently than other TNCs, is door-to-door, so that we can help our customers in and out of their car. And as such, our drivers are specially trained for that. We have them certified in what we call ADA, disability sensitivity, and in the safety of handling passengers in and out of the car.
Okay.
And Commissioners, again, thank you for your time this morning. I know how valuable it is. I echo everything that my colleague just talked about. You asked specifically about our company. I will tell you that a differentiating factor of USERV is that you will find that every employee has a personal story. So when we talk about the safety of our riders, it is paramount. We believe that this background check scheme that we have come up with is a good one. We believe that it is effective, and because we all are personally affected by what goes on, we do our utmost to ensure that the safety of our riders is our #1 priority. So we want you to make sure you know that.
Would the company have any issues committing to the assertions or any commitments or responses in your data requests to our staff?
I'm not sure I understand. Can you explain?
So, yeah, so we had contested proceedings with Brazier and Lyft, and they made a lot of assertions in verbal testimony. We committed those companies. We made contingent our approval of their waivers on them maintaining the assertions or verbal commitments they made. We don't kind of have that here. This is an AM item. Staff has indicated that it was their intention, on my question, that you be committed to the assertions made in the data requests, and I'm asking you, do you have any problem with making that commitment to us?
No, sir, we do not.
Okay. Very good. I think I'm satisfied. Just you won't be offering rides though to the general public. You'll be serving special needs communities exclusively.
No, we don't. We do not have an intention to do that. Our business model is different. It is what we call B2B. So we have a contract with Greater Richmond Transit Company. We have a contract with Frederick Hospital. It is their clients that come to us for those rides through them.
Okay. Fair enough. I appreciate the company and the staff accommodating my questioning, but I did have some level of discomfort with this because of the extensive proceedings we had before and the kind of almost, this is an admin item kind of proceeding we're dealing with this one, and I wanted to make sure that in light of recent happenings in transportation, especially in Schoharie, New York, that we weren't doing something that was going to endanger the riding public in Maryland.
I would like to speak to that just for 1 minute. I do want you to know that staff was very thorough, and We had extensive conversations back and forth because this was something that was very important to them and very important to us. So it has been since July, I believe, that we have been back and forth with transportation staff here at the Public Service Commission. It may seem like it was just a rubber stamp, but I assure you that this was something that we undertook and put some time to.
So let me just say I have the fullest confidence in our staff. They're consummate professionals, and I didn't mean to imply they rubber stamped it. I'm talking about our action that we're taking here today as compared to the previous proceedings that we presided over and in our previous approvals. So our staff does a wonderful job, and they know that I know that. So I didn't want to make that implication. Mr. Chairman, I suspect that do we need to modify?
Can I ask just a question on that? I want to get a clarification. Yeah, to Commissioner O'Donnell's point, the way I read the buck sheet and the order or proposed motion, we do condition it on compliance with requirements imposed in order number 87957, a lift. Does that essentially pick up everything that Commissioner O'Donnell is raising about these modifications? And they're spelled out on page 5, but specifically the modifications discussed in the order. I'm sorry, in the
Yes, it
request,
does.
information request.
Yes, it does.
Can I just
That's fine, I just
beg
want-
to differ a little bit?
Okay.
But those conditions that we put on Razier and Lift specifically said that anything that they said verbally in the testimony on the stand they were committing to in perpetuity or coming back to us to modify them. We don't have that in this case. We don't have that verbal testimony, and so I don't think the previous order says the DRs in this application. In other words, they're different assertions. There's a different flavor in these data response requests that would not be captured by that order, previous order, in my opinion.
Right, but I do believe that the agreement is that the data requests you're going to stand by the data request responses.
Right. So the question then becomes, do we need to slightly modify our motion to make sure we capture that? Because this just says in accordance with order number 87957, which is a little bit different.
I see the point that you may have to.
So, let me try to clarify.
Okay.
Are the responses to the data requests all of the same conditions that are discussed in 87957?
Yes, they are.
Okay. So, perhaps we could get the company on the record right now confirming that they will comply with all the requirements in 87957 on the record here. Perhaps that would help, because if they're the same, then we have their affirmation here in orally on those conditions.
My point is, the questions that are asked in these data requests are not the same questions nor same responses that we got in 85957. They're not. They're different questions.
Right, but the conditions, that's why I asked the question. The conditions
Right.
that
data
they're
request-
discussing in there are the same conditions, and that's what I was trying to get to. But first, I would like to have the company affirm either way, whether we change it or not. I'd like to have the company confirm on the record that they agree to all the requirements of 87957.
Yes, we do.
Okay, thank you.
We've gotten a response to that. That doesn't satisfy my question.
that was one of my
I can vote no,
We prefer you don't.
right? I know that, so.
Can we say something along the lines and consistent with the data request for this administrative meeting item?
The responses to the data
Yeah.
requests, yes.
Or you can certainly reference the buck sheet itself. That's a part of the
Okay.
document.
That would satisfy me, whatever the wordsmithing is. I just want to make sure we're holding the company's feet to the fire on this application, considering it is a truncated proceeding compared to our previous long history of waivers, exactly 2.
Okay.
Well, we can reference the company's buck sheet itself. The staff's buck sheet. They actually in the buck sheet they reference the bullet points that Commissioner O'Donnell is concerned about, and I would share his concern as well to make sure that we capture this accurately. So
You're talking about the bullets on page 5 of the buck sheet?
yes,
Okay, great.
I'm talking.
Okay.
Can I try the motion, see if that works for you?
Sure.
Ready? Everybody ready?
Mm-hmm.
Okay.
And this will be in the third paragraph then of the proposed motion?
Yes.
Okay.
Mr. Chairman, I move that we grant USERV a waiver of the fingerprint-based background check required by Public Utility Article 10-104B. Approve an alternative background check process for the company as specified in staff's comments and accompanying exhibits dated October 18th, 2018, to be used in lieu of the Public Utility Article 10-104B fingerprint-based background check. Direct the company to comply with all the requirements imposed by the Commission in Order Number 87957 in granting a similar waiver to Lyft Inc. and Razor LLC and its responses to the data request contained in staff's comments numbered T-6387 dated October 18th, 2018. And direct the company to notify the Commission within 10 business days regarding whether the company accepts all of the conditions imposed by the company in connection with the waiver.
Great. Is there a second?
Second.
Great. All in favor?
Aye.
Aye.
Any opposed? The motion carries. All right, item number 3.
Item number 3 is the Declaration of Networks Group, Inc., filed on September 24, 2018, petition for a grant of designation as a high-cost eligible telecommunications carrier within certain areas of Maryland.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This addresses a filing by Declarations Network Group, I'll call them DNG, for designation as a eligible telecommunications carrier, which I'll refer to as an ETC. DNG was selected by the Federal Communications Commission as a winning bidder in the Connect America Fund Phase 2 auction to provide and expand broadband service in rural areas of Garrett County, Maryland. Broadband service is a high-speed internet service. As part of the post-auction procedures established by the FCC, DNG is required to obtain high-cost ETC designation within all areas where DNG has been named the winning bidder in the FCC auction. The Commission's designation of DNG as an ETC would allow DNG to receive reimbursement from the federal government under the Universal Service Fund to provide service to remote and underserved communities in Garrett County. Designation of DNG as an ETC will give consumers increased choice and access to new technologies at affordable rates. Therefore, staff believes that granting DNG ETC status is in the public interest. Staff requests that this approval, though, be conditioned on giving other competitive carriers an opportunity to file comments with the Commission on the application. Therefore, staff recommends the Commission determine that designating DNG as an eligible telecommunications carrier is in the public interest. Staff recommends that the Commission grant their application unless adverse comments are filed within 30 days.
Okay, thank you. Are there any questions from commissioners? Is the company here or anyone else wishing to be heard on this issue? If not, is there a motion?
Mr. Chairman, I move the Commission find that the designation of Declaration Networks Group Incorporated as an eligible telecommunications carrier, ETC, is in the public interest, and grant the company ETC designation pursuant to 47 U.S.C. 214E for the service territory specified in its application with an effective date of October 24, 2018, provided no adverse comments are filed within the 30 days following the effective date and the company complies with the Commission requirements described in the May 4th, 2012 notice to ETCs.
Is there a second?
Second.
All in favor?
Aye.
Any opposed? The motion carries.
Item number 4 is Just Energy Services LLC, filed on October 9, 2018, request to amend its gas supplier's license.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This item addresses a request by an existing natural gas supplier named Just Energy Services for authorization to expand its service area to include residential, commercial, and industrial customers in the Washington Gas Light service area. The Commission has authorized Just Energy to serve residential and commercial customers in the Baltimore Gas and Electric service territory. Just Energy is up to date on its payment of Commission assessments. There is one open complaint against Just Energy at the Commission, which alleges misrepresentation regarding their energy products. Just Energy is registered with the Maryland Departments of Assessments and Taxation and is in good standing to conduct business in Maryland. Therefore, staff recommends that the Commission authorize Just Energy to expand its surface area to include the Washington Gas area.
Great, thank you. Any questions for staff? Is the company here and wishing to be heard, or anyone wishing to be heard on this? If not, is there a motion?
Yes, Mr. Chairman, I'd move that we grant the company's request to amend its natural gas supplier license to include residential, commercial, and industrial customers within Washington Gas Light Company's service territory.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion carries.
I believe items 5 and 6 can be taken together. Item 5 is Washington Gas Light Company, filed on October 2, 2018, request for a waiver of Comar 20.310508C3 for the 2018-2019 winter heating season. And item 6 is the Potomac Edison Company, filed on August 24, 2018, a request for waiver of Comar 20.310508C3 for the 2018-2019 winter heating season.
Good morning again, Kenneth Albert on behalf of staff. I would ask if we could we did separate presentations for the Washington Gas Light and Potomac Edison. There's no real substantive differences, but that's how we had presented it. It's okay with the commissioners?
That's fine, thank you.
Okay. The first one addresses the request by Washington Gas for a waiver of certain restrictions on the use of financial aid by low-income utility customers to pay the utility bill. Under the Utility Service Protection Program, USPP, the utility establishes a uniform monthly payment for the customer, we refer to that as budget billing, as a way to reduce the risk of service termination due to non-payment of bills. The arrearage of a first-time applicant for the USPP program cannot exceed $400. The arrearage of a customer that's returning to the USPP program after termination due to non-payment cannot exceed the greater of $400 or the amount covering the monthly installments in arrears in the customer's equal payment account, along with supplemental payment accounts at the date of reconnection. Comar allows a first-time applicant for the USPP to apply to its past unpaid utility charges, the arrearages. All are part of the financial aid that the applicant receives under the Maryland Energy Assistance Program, the MEAP, we refer to as MEAP, to reduce its arrearage to an amount that allows the customer to qualify for the USPP. But Comar says that this election to apply the MEAP grant to past arrearages is for one time only, and that subsequent MEAP benefits may not be used to reduce arrearages. That's why WGL is seeking a waiver of the restriction on a customer's use of its MEAP grant to pay an arrearage. In its 1988 decision on this issue, the Commission indicated that its adoption of this restriction of applying a MEAP grant to reduce an arrearage was based on the Commission's view that the arrearage should be retired by the customer on a prospective basis as part of their uniform monthly billing payments. However, some of WGL's, low-income customers face a hardship from this ban on applying the MEAP grant to arrearages to reduce the arrearage to an amount that allows them to qualify for the USPP. At the October 17th administrative meeting, the Commission did grant a similar waiver to Baltimore Gas and Electric. BG&E and the other major utilities have received this waiver in the last several years, and indeed the next item we'll be dealing with is Potomac Edison. Staff believes that WGL's request for a waiver promotes maximum participation in the USPP and remains an important tool for customers to manage their utility accounts during the winter heating season. Therefore, staff recommends that the Commission grant the waiver requested by WGL.
Thank you. Are there any questions for staff? Is the company here and wishing to be heard?
Good morning. Donald Hayes, appearing on behalf of Washington Gas Light Company. I have nothing to add beyond what Mr. Albert stated. He stated it accurately. We appreciate your consideration of this request and would request that you approve the waiver.
Very good, thank you. Any question for company? If not, why don't we go ahead and hear the second presentation?
Morning, Mr. Chairman, Commissioners. Phil Vanderheiden, part of staff. Won't cover the details Mr. Albert covered on the nature of the regulation. I will note that Potomac Edison is asking for the same waiver affecting the requirement to reconnect customers who are eligible for USPP. Potomac Edison has made this request since 2014 and each year since then. The staff has reviewed the company's request and arrearage data from the previous season. Out of the 2,733 USPP participants, only a small number, about 7 of them, were actually disconnected during the season, thus are requiring the waiver. In 2017, about 178 accounts requested the use of MEAP funds to reduce arrearages. of which the average retirement is $294.82. This is on Table 1 on page 4 of the staff bug sheet. Observing that the arrearage amount is lower than the $400 threshold for ME participation, it's not immediately clear why it's necessary for this waiver to reconnect customers, but it's also possible that the arrearage amounts, all of whom were not sufficient to reduce the arrearage below the $400 threshold. And that's something that we've attempted to investigate with the company, but unfortunately that information is not something they have available. Staff is recommending approval of the waiver in order to maintain a consistent approach with the previous season and what the Commission has already awarded this year, noting that BG&E asked for the same thing was granted last week. We think it may be appropriate for the next season to examine the effectiveness of applying these MEEP grants to meet that $400 threshold, or to at least reconsider the threshold level to which customers have to reduce their outstanding balances. We think the original intent of the regulation that we've noted before was to allow the MEEP grant to be applied to the customer's annual bill for the purpose of giving them a lower even monthly payment plan on the USPP. And we've noted here and have noted previously that by applying these grants, it kind of erodes that ability. And so customers are really seeing, after their MEEP grants applied to get them into the USPP program, they're really facing their full electric bill without any assistance, and there's an awful lot of difficulty for those customers to continue to pay that bill down. So there appears to be kind of a disconnect in the way the intent of these regulations was set up, but from looking at the different companies' levels of arrearages, the number of customers that have been disconnected, it's not entirely the same for each company. But we're still recommending that you approve the waiver to be consistent with past practice and with the other utilities this season.
Great. Thank you for your presentation. Are there any questions from commissioners? Commissioner Upland.
Thank you. Just one question, and if staff doesn't know, then perhaps Mr. Trout would. But you noted that in your presentation that the companies was made this request for the first time in 2014. We know from some of the other requests that we've received from other companies that these requests for waivers have been happening for a couple of decades now. So what was the company's practice prior to 2014 with regards to these types of customers?
I don't know the answer to that, Your Honor.
Okay.
Well, great. Why don't we recognize representative from the company, Mr. Trout. Can you please introduce yourself and respond to Commissioner Linton?
I will. Thank you. Jeffrey Trout, counsel for Potomac Edison. All right, first on Commissioner Linton's question. I don't believe that we requested waivers prior to 2014, at least not during the period from 2007 to 2013. And I believe what prompted us to request the waiver in 2014 was a commission decision which is referenced in our application, at least I hope it's referenced in our application. Yes, it's the September 23rd, 2014 commission order number 86-631 in case 8903. After the commission issued that decision and I reviewed it, we concluded that we needed to submit these waiver applications, and we have been doing that. So that's the explanation for why ours don't go back as far as, for example, BGE's do. More generally, we obviously concur with staff's recommendation that the waiver be granted. We also concur with the thought that staff articulated this morning and that Commissioners O'Donnell and Linton articulated last week with respect to the BGE matter, that it's unsatisfactory to come in and ask for these waivers every year. There's a risk, it hasn't been realized to date, but there's a risk of inconsistent treatment of the different companies in what should be a generalized application of generalized rules. The Commission could benefit from input from all interested stakeholders as to how the rules may better work, may better fit together. Commissioner Linton pointed out last week that there are 3 different sets of rules that are intersecting in this area, and some of these rules are 30 years old or more. So the thought that between now and next winter that we would look at this question more broadly, and not just at whether there should be, to your point you made last week, Commissioner O'Donnell, which I thought was a very good one, we shouldn't just be looking at the idea of memorializing permanently these waivers. We should be looking at the broader question of, do the rules still work the way they were intended? Have things changed? Should we be doing this in a better way? And apply that better approach across all the companies. We would support doing all of those things between now and next winter. And in the meantime, we would like to have the waiver to be able to help our customers this winter. There is one thing that Mr. Vanderheyden said this morning that I want to, not exactly correct, but correct the impression that it might have created. He said that last year there were 7 people who were disconnected and then were reconnected as a result of receiving this waiver. That is technically correct, but there were in fact 253 customers who benefited from our ability to use this tool in the last winter heating season. We would anticipate that a similar number, that same ballpark of number of customers would benefit from having the waiver available to use this winter heating season. So this is something that's important to literally hundreds of our customers. And for that reason, we support staff's recommendation that our waiver request should be granted.
Quick question, I guess, staff, and I appreciate both the history lesson and the chronicling of the discussion on this. I think it's right, spot on, so thank you for that. Has staff given thought to what forum this investigation of the COMARs, the appropriate COMARs, would take? How will we proceed in this investigation?
Your Honor, there is Ms. Garoppolo indicated that the OHEP work group has been recommended as a means to work this out.
Okay, and we participate, we're participants in that work group, or who leads that work group?
I believe the staff representative is Ms. Garoppolo.
Okay, very good. Thank you. That answers my question.
Just to follow up on that, is this something that is being brought to the attention of the OHEP work group, or how does that actually get initiated? I mean, do we just assume it's happening, or what?
My understanding
we need to take a step from up here.
Is that staff has already received some direction to do that.
Okay.
And that's in process.
Very good. Thank you. With that, are there any other questions for staff or the company? If not, is there a motion for items number 5 and 6?
Yes, Mr. Chairman, with respect to items number 5 and 6, I move that we grant the companies a waiver of COMAR 20-31-05-08C3 for the 2018-2019 heating season.
Okay, is there a second?
Second.
All in favor?
Aye.
Any opposed? The motion carries.
Thank you.
Item number 7 is Baltimore Gas and Electric Company, filed on September 21, 2018. Calculation of the gas administrative charge under Rider 12 of its gas service tariff, effective November 1, 2018.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. This is BGE's annual revision to its gas administrator charge under Rider 12 of its gas service tariff, and to be effective November 1st, 2018. The calculation of the gas administrator charge is made pursuant to the stipulation and settlement agreement in Phase 3 of case number 8950. The purpose of the gas administrator charge is to allocate costs relating to providing gas commodity to BGE's gas sales service customers. The gas administrator charge includes the gas commodity portion of credit and collections cost, commodity billing, uncollectibles, and the PSC assessment for revenues associated with sales service. The gas administrator charge is updated following any changes to gas base rates to reflect the test year amounts of the specific items included in the charge. These costs were formerly embedded in the gas distribution rate, but were removed so as to eliminate or at least minimize any subsidy from gas distribution service to gas sales service. Customers do not see the gas administrative charge as a separate line item on their bills because it is included as part of the gas commodity charge. Staff has reviewed the gas administrative charge calculations and determined that the revised calculations are accurate and consistent with the calculation required under the case number 8950 settlement. The new rates represent a slight decrease compared to the rates in effect through the end of this month. Staff recommends that the Commission accept the new gas administrative charge for filing effective November 1st, 2018.
Great, thank you. Are there any questions for staff? See, there is a representative for the company, Mr. Herson.
Morning, Commissioners. Daniel Herson for Baltimore Gas and Electric. I have nothing to add to Mr. Spivak's presentation. We're just here for questions. If you have any.
Great, thank you. Are there any questions for the company? If not, is there a motion?
Mr. Chairman, I move the Commission accept the new gas administrative charge for filing effective November 1st, 2018.
Is there a second?
Second.
All those in favor?
Aye.
Opposed? The motion carries.
The next item, item 8, is Baltimore Gas and Electric Company, filed on September 24, 2018. Request for a waiver of CPCN requirements for a project to reconductor a portion of an existing 115 kV overhead transmission line in Baltimore County, Maryland.
Good morning, Commissioners. Michael Dean on behalf of staff. Item 8 is a filing by Baltimore Gas Electric Company requesting a waiver of the certificate of public convenience and necessity requirement for the reconductoring of 0.27 miles of 115 kV overhead transmission line between the Northwest and Northwest number 2 substations in Baltimore County. Under Public Utilities Section 7-207, a person normally must obtain a certificate of public convenience and necessity prior to commencing construction on a modification to an overhead transmission line with a capacity greater than 69 kilovolts. However, the statute allows the Commission to waive the requirement to obtain the certificate if the Commission finds that the construction does not require new rights-of-way or real property or require higher structures to accommodate increased voltage or larger conductors. Baltimore Gas Electric Company plans to replace the existing conductor with one slightly larger, but will not be installing larger structures or obtaining new real property or rights-of-way. As discussed in staff's comments, the work is required by PJM through the RTEP process, which determined that a load drop was possible in the area upon failure of a 230 kilovolt transformer. The reconductoring will cost about $1.2 million and is scheduled for 2019. The company will also perform other work at the Northwest substation. Staff has reviewed the filing and after conducting discovery determined that the planned work meets the criteria for a waiver of the Certificate of Public Convenience and Necessity requirement. Staff also contacted the Power Plant Research Program of the Department of Natural Resources, which during a limited review noted wetlands in the area and suggested the company contact the Wildlife and Heritage Service. Staff understands that the company has been in contact with the Power Plant Research Program concerning its recommendations. Staff recommends that the Commission waive the requirement to obtain a certificate of public convenience and necessity for this project pursuant to Public Utilities Article Section 7-207B4I. Staff also recommends that the Commission direct the company to provide a more detailed description of reconductoring activities to the Power Plant Research Program and submit an environmental review request letter to the Wildlife and Heritage Service.
Thank you, Mr. Dean. Are there any questions for staff?
Yes.
Commissioner.
Mr. Dean, would we expect that the other companies participating in the community solar would be filing similar tariff changes or no?
You may have the wrong item, Commissioner.
Oh. Which one am I on? Oh, sorry, we're on the CPCN. Sorry.
Great.
We can prepare that question, the answer to the question for the next one.
Great. We have Mr. Herson from the company. Do you have anything to add to
Daniel Herson again for Baltimore Gas and Electric. I just want to confirm to the Commission that we did send PPRP the requested additional details, and we did submit the letter to Wildlife and Heritage Service. So I believe at this point we've met the recommended actions by staff. That's all I had to add. Thank you.
Great, thank you. Are there any further questions? Is there a motion for item number 8?
Yes, Mr. Chairman. For item number 8, I move that we grant the requested waiver of the requirements to obtain a certificate of public convenience and necessity for this project pursuant to Public Utilities Article Section 7-207B4I, and direct the company to provide a more detailed description of reconducting activities to the PPRP and submit an environmental review request letter to the Wildlife Heritage Service.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion carries.
Thank you.
Item number 9 is Baltimore Gas and Electric Company, filed on September 19, 2018, Supplement 619 to PSC Maryland E6, Rider 32, Community Energy Pilot Program, effective October 26, 2018.
Good morning, Mr. Chairman and Commissioners. This filing is a revision to BG&E's Community Solar Program tariff. PHI companies Delmarva and Pepco, as well as Potomac Edison, proposed a similar revision, which was accepted on last week's agenda.
Thank you.
BG&E's revisions are made for the same reasons as explained as for the other utilities in last week's presentation. I'm just going to touch on the highlights of those changes. The tariff revisions will accomplish 3 objectives. First, to set for BG&E a start date for the application process for years 2 and 3. Second, to close out the year 1 program capacity, effectively rolling that capacity into the year 2-3 capacity. And third, to establish a 2-project limit to the interconnection application procedures for years 2 and 3. BG&E will close year 1 on Friday, October 26th at 5 p.m. The company will open year 2 on November 5th, 2018 at 12 p.m. So this Friday, year 1's capacity will be closed out. There'll be a week, and then the following Monday, BG&E will begin accepting interconnection applications for years 2 and 3. BG&E's tariff also includes a limit for each subscriber organization for the 2 projects, which is good for the initial 20 business days. And Table 6 on page 5 shows the status of BG&E's project queue. As of last week, there are 21 reserved projects with 3 projects on the year 1 wait list. And the year 1 wait list will be closed out this Friday, so all of the projects accepted for years 2 and 3 will be starting fresh. Staff is recommending acceptance of the revised tariff.
Great, thank you. Are there any questions for staff? Commissioner Herman?
No.
Oh, I thought you pushed your button, sorry.
No.
Okay.
That's my motion.
Does the company wish to be heard on this, Mr. Herzog?
No, I have nothing to add to Mr. Vanderheyden's remarks. Thank you.
Great, thank you. Is there a motion?
Yes, Mr. Chairman, I move we accept the tariff revisions for filing to be effective on or after October 26, 2018.
Is there a second? All in favor?
Aye.
Opposed? The motion carries.
Item number 10 is DNR PPRP, filed on September 20, 2018, recommended PPRP requirements for Todd Solar modifications request, case number 9412.
Good morning, Commissioners. DeAndre Wilson here for staff. On June 27, 2016, in case number 9412, the Maryland Public Service Commission issued order number 876901, granting Todd Solar a CBCN, which included several licensing conditions proposed by a power plant research program. On June 29, 2018, Todd Solar filed a written request with the Commission requesting a modification to this CPCN. In its filing, Todd Solar requests 1. Authorization to modify its original engineering design from an overhead configuration to an underground configuration. And 2. An extension of the construction and operational deadlines set by PPRP in its licensing condition number 4, after being granted a 3-year extension for the construction of the site by Dorchester County Board of Appeals. On July 30th, 2018, after performing an independent evaluation of Todd Solar's modification request, PPRP filed a written response to Todd Solar's CPCN modification request in support of the company's request, with certain conditions and or stipulations, which the Commission approved on August 22nd of 2018. On September 20th, 2018, PPRP filed its revised licensing conditions and stipulations in connections with Todd Solar CBCN modification requests. PPRP's revised licensing conditions are: 1. Todd Solar LLC shall submit a copy of its county-approved site plan to PPRP and also file the plan with the PSC, with the Commission, as a supplement to its CBCN application. 2. Todd Solar LLC must be responsive to any new data requests from PPRP. 3. As necessary, PPRP will submit any recommended modifications to the licensing conditions as well as new conditions to be added to the CPCN for consideration by the Commission 60 days after the county-approved site plan is filed. 4. All parties to the original case should have an opportunity to provide written comments regarding any recommended modifications and/or additions to the conditions in the existing CPCN. And 5. Condition 4 of Appendix A to the CPCN will not be further extended past October 26, 2020 for construction and October 26, 2021 for operation. Staff has reviewed PPRP's filing and recommends that the Commission accept the revised licensing conditions filed by PPRP for the requested CPCN modification.
Great, thank you, Mr. Wilson. Are there any questions for staff? Commissioner O'Donnell.
Thank you, Mr. Chairman. We've had these extensions before, and there was the notion that there would be no further discretion of the Commission to grant extensions, I think. Does this new language in the PPRP conditions preclude us or restrict us in any future decisions regarding extensions to these applications? My ears perked up when you said under no, I think you said under no conditions would they be extended beyond a date certain, and I know that PPRP has added that language before, which is seemed to be constraining the future discretion of the Commission.
It does. I do think that the Commission actually will have some discretion ultimately as well, because we don't know necessarily what's going to happen 3 years hence, but I'll let Mr. Tolson speak.
Morning, Commissioner. Steve Tolson, Assistant Attorney General Counsel for PPRP. I believe that Mr. Wilson was reading from the old version. The revised version has a provision in there that says that if the project is not completed and operational by these deadlines, comma, or further extended by the PSC, we took good note of our last visit to the meeting and put that in there. So it is not an issue, sir.
Thank you for the clarification, Mr. Tolson. I appreciate it.
We have a representative from the company.
Sure. Good morning, Mr. Chairman, Commissioners. David Bugelmans on behalf of Todd Solar LLC. Just to provide a bit more clarity, I believe Mr. Towson was correct that when staff read the 5 conditions, those were PPRP's initial sort of requirements to create a process to update its licensing conditions, which it filed with the Commission in its most recent filing. And it submitted both clean and red line versions of those conditions. And as Mr. Tolson indicated, it's clear in there that a further extension could be granted by the Commission upon a further application and approval. The project supports PPRP's revised conditions. We believe they're consistent with PPRP's conditions for more recently permitted projects. We did point out in a letter filed about a month or so ago several typos in those conditions. We would respectfully request for the Commission to address those typos, but otherwise we're in full support of the revised conditions. I'm happy to answer any questions. Thank you.
Great, thank you. Are there any questions?
Mr. Chairman, let me just say that my line of questions in this regard are in no way intended to signal my encouragement or support, even potential support for future requests for extensions. They were simply to maintain the integrity of the prerogative of the Commission in the future.
Thank you, Commissioner O'Donnell. Are there any, Commissioner Linton?
Thank you. Just one question on, I'm looking at page 5 of the staff's buck sheet. The second sub-bullet, which references, I believe, references back to one of the conditions that were presented that we were just read a few moments ago, regarding the requirement that the applicant shall not begin construction until all comments have been addressed. And I'm concluding this is comments related to any future modifications or requests for extension. My question is, who is supposed to address any comments, and what level of satisfaction of those comments is supposed to be reached before the company could move forward?
Commissioner, I believe, if I'm looking at the right bullet here, I believe these sub-bullets are in reference to one of the revised conditions the PPRP submitted, which is a decommissioning condition. The difference between the original condition and the revised condition is PPRP's original decommissioning condition didn't require approval of the decommissioning plan, whereas the new condition does. And so I believe this bullet's referring to the requirements of that condition, which specifies that all comments need to be addressed to the plan before construction can begin. So I think that's just limited to that one specific condition and not to any other part of the CPC under the conditions.
Okay, so just PPRP is supposed to address those concerns or comments if they're raised?
So to my knowledge, there's only been one project or actually it's two projects that have filed for approval of a decommissioning plan under this new condition. It's MD Solar 1 and MD Solar 2. Those are still in process. Those are going to be heard in early November, I believe. My understanding would be, it's an issue that would likely, in most cases, come before an administrative meeting. So the parties to the case could provide comments. I'm sure the commission would likely consider the comments of the county or any other entity that would want to provide comments. So I think it would occur in the context of an administrative meeting.
Okay. All right. Thank you.
Any other questions for item number 10? If not, is there a motion?
Mr. Chairman, for item number 10, I move the commission accept the newly revised licensing conditions submitted by DNR PPRP for the requested CPCN modification.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion carries.
Item number 11 is Lagore Solar Energy Center LLC and ESA Sparks Glencoe LLC, filed on July 31, 2018, a joint request for an extension of operation deadline.
Good morning, members of the Commission. Nick Garofalo on behalf of Commission staff. By letter dated July 30th, 2018, Lagore Solar Energy Center and ESA Sparks Glencoe requested approximately 24 months from the date of filing a completed application with the Commission to bring their projects into full operation. Since that time, ESA Sparks Glencoe LLC has withdrawn its request because its project involves a pending legal challenge in Baltimore County and has been granted a day-for-day extension under Comar 20-620304C3B by BGE, the electric company in whose service territory it is authorized to be located. Lagore was accepted into the pilot so we aren't considering ESA Sparks today. As for Lagore was accepted into the community solar pilot on October 31, 2017, making its 18-month deadline under Comar April 30th, 2019. Applicant states that all required certifications and permits are expected to be received by April 15, 2019. Staff recommends that the Commission, consistent with its previous rulings, extend applicant's operation deadline to June 1, 2019. A waiver of the regulatory deadline of approximately 60 days. Should additional time be needed, applicant may so request when the timing of events becomes more certain.
Great, thank you. Any questions for staff? Can I just ask a question? In a lot of these, it says it takes about 120 days, 6 months for construction to be completed. Is that staff's understanding?
Some say 90 days.
Okay.
In this case, it was 120 days, so I think that's this does not get them to that 120-day period if we start it in April as opposed to in March.
Well, and that's the other. It seems that we're hearing consistently that they cannot do construction. These developers cannot do construction during the winter months, and really it's April. So should we be considering just an extra month just to get them to the whole 120 days, or is there a reason staff specifically stops just short of the time that the company says
Well, I
it needs
guess
for construction?
we can't, so we don't feel we're certain of these time frames, and Mr. Bugelmans can let you know the level of his certainty. And we think it's a short time frame that they need for building, and that if we could kind of shepherd all these people who are asking for extensions to beginning around June 1, that might be better. If not for the program as a whole, at a minimum, it would be better for the writing the report as a whole. And we think that they're not harmed by being granted an extension to June 1, since if they do need that extra month or extra 6 weeks or whatever it is, they could come back in.
Right, they can come back.
We might be harmed. You might be harmed.
Okay.
I might be harmed, but we don't think the applicant would be harmed.
Okay. Well, great. We have Mr. Bugelmans. Would you like to address this issue?
Yes, Your Honor. So the issue with staff's proposal is this project entered the program a few months behind the other project. So the operational deadline for this project under the existing program rules is April 30th. So staff is essentially recommending a 30-day extension. As we indicated in our letter, the construction start date is anticipated for April 15th, and construction would take about 3 months. Consistent with previous requests, we recommended a 6-month extension. As we indicated in our letter as well, there is essentially a holdup once the project submitted for its zoning certificate from Frederick County, where they had to wait for final interconnection design, which took about 8 months. So we thought 6 months was consistent with previous requests and would compensate for that lost time and provide enough wiggle room to finish construction and prevent us from having to come back here. But it would take about 3 months. So the anticipated operational date, assuming April 15th works out, would be July 30th, 2019.
Okay, great. Thank you.
Question. Mr. Bugelmans, why April 15th? Why do you anticipate waiting till the middle of April to start construction?
There's additional approvals that need to occur. If you could have your indulgence real quick. Let me take a look here. Sorry, let me just refresh my recollection.
I think staff indicated maybe it was weather related.
Weather is a piece of it. The issue is that the project needs to apply, it needs to finish basically its zoning certificate application. So it needs to complete the construction drawings and submit those. Then following that, there's further approvals such as stormwater approvals, sediment erosion control, and then finally the ministerial permits. And then that combined with financing, the anticipated construction date would be April 15th.
So your original plan, you're behind those permitting kind of milestone dates? Is that what I'm hearing you say, that your original plan had anticipated getting them earlier and now you're getting them later than you anticipated?
I think that's correct, Your Honor. The issue is the project was held up in the zoning certificate stage. Essentially, this is the first project, or one of the first projects, to apply for approval under Frederick County's new zoning ordinance, which the Commission's seen in some CBCN cases. For community solar projects, it's a permitted use, but you still need a zoning certificate, which essentially you need to show that the project has been designed to satisfy certain requirements under the zoning ordinance.
I get
and
that.
That's where the held
How long does that process take, and why is it behind schedule?
That process took about 8 months longer than anticipated. Once the project submitted, which I believe was in October of 2017, the county responded that it had to submit a completed construction drawing plan for the project. The issue was that it needed the project needed a final interconnection design from Potomac Edison, which took about 8 months from that point. So they're unable to move forward until about June of this year, which is when they initially filed their request for a waiver.
I see. Well, we're October of 2018, and is there any chance that you can start construction in March? I mean, there's nothing weather-related in March, surely, that's going to stop you from construction. Actually, it may be a more advantageous month in March to start by April, which is typically very muddy.
My understanding, Your Honor, is that with all the steps left in the process, April 15th is sort of their target date, is what they believe is realistic. I know it's just 1 month, but it really can make a difference in terms of the timeline for these projects.
I heard your pleading. I'm asking you, can you start earlier than that? Are they targeting? Is that their goal to start then?
I understand. And I, with all these requests, that's one of my questions. Is when's the earliest date you can start? This developer's response was that's the earliest date we can start. So that's my understanding.
All right. Well, my goal is certainly not to make it comfortable to keep applying for these requests that keep extending our entire pilot, first year of our pilot, beyond its original deadline. So you're suggesting what date?
So the letter requested a 6-month extension, which would be, I believe, until October 30th of 2019. But if you wanted to carefully tailor this, so it would line up with the projected 3-month timeline to complete construction and begin operations, we believe July 30th, 2019 would be tailored. It would be tight but feasible.
So if we were to approve staff's recommendation consistent with our previous dates on this, we might have you and or your client go back to the table and sharpen the pencil and see if you might be able to be more consistent. And if you can't, then you could come back in, right?
Certainly we could come back in. The issue with this, and the reason why I think some of these requests have been a bit longer than, for instance, like a 3-month projected window to complete construction, is that when these projects go to get financing, well, it's, obviously we could advise to financing counterparty that the commission would likely consider this request and there's a chance it would be granted. That's often not enough. So what they need up front is certainty that they can realistically complete construction by the deadline. So that's really what we've been seeking with these. So I agree we could come back in, but I think
your client made the commitment under the original outlines of the program. We didn't. They said yes, we can do this. I mean, we're seeing these almost on a continuous basis. These extensions. So it's throwing the whole test, the whole proof of concept out the window almost.
I think that's right to an extent. Commissioner, I think what's apparent with what's occurred with all these extension requests is I think it's a lesson learned for future years. I don't think staff or the commission intended to create this type of bottleneck, and I think the consistency with which we've seen these requests suggests that there really is, I think, an issue with the program design in this regard, which is an issue it's probably best left to the working group to present to the commission to resolve. But this really has been a consistent problem across all projects, and I know
I'm not sure it's across all projects. I'm not sure that's the case. There are other projects that have moved forward or are moving forward.
I think that's correct. I did look in many of the service territories. The vast majority of projects have come in and requested extensions, so it is a significant majority. But you are right. It's likely not all of them.
And some of them are due to legal challenges. Some of them are due to other things beyond the control of the applicant. But I'm just not sure all of them fit into that case. So I don't know.
Commissioners, any other questions from commissioners?
I just want to confirm that I heard you say that while you requested 6 months through October, by going till the end of July, you believe you can do that, and that would shorten the extension. Is that right?
Correct, Your Honor.
Okay. Thank you.
Can I ask just a question of, oh, I'm sorry.
No, I was just going to ask the staff. Their recommendation was until June 1st, so, we got about a 60-day difference there.
Yeah, so June 1st, there's nothing magic about it. When people first began coming in, they estimated, they explained what their problem was. They, I think, all said that it took a 90-day period to build the project once all permits were obtained. And they asked, a number of them asked for time around June 1. But as more and more of these came in and they were granted a waiver of the time frame, the 18-month time frame, the dates started getting longer and longer. And so we're trying to maybe pull them back to June 1, because at this point, so there's nothing magic, in answer to your question, nothing magic about June 1, but we're trying to keep them all, the year ones, starting at about the same time. Well, if not starting, at least completed and in the program by about the same period of time, which, if you look at most of them that have been granted extensions, it's been by the commission, then that's been to June 1.
So would you prefer, or would you recommend then that, assuming the commission were to grant a waiver, that we grant the waiver for the June 1 period, but then require that the company come in if they need more time? Or would you recommend that we allow them more time now?
Well, our comments recommend June 1, but clearly it's expedient for everyone if you grant it until July 30th, and they finish prior to July 30th.
Okay. All right. Thank you.
I was just going to ask a question on the is there something magical about the 1st as opposed to the end of the month, July 30th versus August 1st? I know staff have always come in for the 1st of a month.
Well, we pick the 1st of the month, so we aren't picking, sometimes if you add a certain number of months to the date, the 18 months, it turns out to be the 7th of the month or something like that. So we just pick the 1st, but June 30th would be a month longer. It would be splitting the difference between what Mr. Bugelmans is asking for and what we're stating. It's your waiver, and I think you should handle it however you want. And our reason for June 1 is what I've said. If Mr. Bugelmans were able, but I think he really can't, in fairness to him, say, and we would be definitely finished by July 15th, then we would say, great, let's make July 20th your deadline, because that gives you 5 days to play around with. But I think his problem and my problem reading his filings is that neither one of us know for sure.
Well, I think in response to staff, respectfully, I think July 30th is a date where they're reasonably certain they can achieve operations by that date. I think looking back at these requests, I can't speak for staff, but most of these requests were for projects that had an operational deadline in February. But as I said earlier, this project entered into the program later. So it's possible that staff was attempting to provide maybe a 4 or so month extension and try to be consistent. But if you apply it to this project, where it's 2 months behind, it's essentially a very, very small extension. So in a way, sticking to June 1st wouldn't be consistent with previous commission decisions. I think also if you look at some of the decisions, the commission did offer extensions until July, carefully tailored to the circumstances, but for projects that had operational deadlines that were in February. So I think July 30th is a reasonable deadline. I think it's tailored to something that's feasible on the ground. I think once you start to move away from that, then it's essentially no extension, and it's just not a feasible deadline in terms of what the project's projecting it can do in terms of constructing and beginning operations.
Great. Thank you very much. Well, maybe we have a little discussion here. I guess the way I feel on this is, since it is a pilot, and I think we are learning things. We're learning that maybe some of our deadlines were maybe a little too tight. We were a little optimistic in how quickly we can get these things done. I would like to suggest that we go ahead and tailor this to a July 30th, since that is what the company says is the time needed from the time that they can begin to begin construction in April. So, again, I hear that it's a possibility if we don't do that, they will have to come in, and that could also cause other issues with the developer and their financing. So I just want to put that on the table, that we alter the proposed motion to July 30th date. Any other thoughts or comments?
I think that's fair. I would share, or at least state the concern that this is a pilot program, and we are learning a lot now, but we also have some obligations to the General Assembly to produce a report, and the amount of data we're going to have for it is not. It's getting smaller and smaller. I don't know how much is going to be in there, but we'll certainly have a lot of other lessons we can share, but it may not be what they were initially expecting. But I don't want a waiver of 60 days to impact the company's ability to move forward with this project, especially since it's also going to be reaching a part of our community that's somewhat difficult to reach for these types of projects. So I'd be comfortable with the July 30th date. I do think that the message should go out that we're getting very concerned with the amount of waivers and requests for waivers, and so we aren't expecting too many more of them to come through.
Okay, thank you.
I'll just say this. I'm not going to support the change, although I do understand the argument made for the change. My opposition will be so that I can signal my support for staff's stated desire to kind of hold the applicant's feet to the fire and keep these things moving per previous discussions and decisions, and I appreciate that. So I'm going to support staff's original motion. I also want to signal that my frustration level with these continuing stream of waivers has caused me to come to the end of my patience threshold, I believe. So for both of those reasons, I'm going to vote no on the modification.
Commissioner Herman, do you have anything to say before we ask for motion?
I support at July 30th. I'm comfortable with July 30th.
Okay, very good. With that, is there a motion?
Yes, Mr. Chairman. For item number 11, I would move that we grant the request of waiver of COMAR 20.62.03.04C2 as it applies to Lagora Solar Energy Center, LLC, for 60 days or until July 30th, 2019.
All in favor?
Aye.
Opposed?
Opposed.
Okay. Thank you. The motion carries.
Thank you.
The next item is item 12, Forefront Power LLC, filed on August 2, 2018. Request for a waiver of the 350 subscriber cap for community solar energy generating systems.
So this is, as the Executive Secretary noted, a request on behalf of Forefront Power LLC and its affiliates, a waiver of the 350 subscriber cap for community solar energy generating systems. This is prescribed by COMAR 20.62.02.03A. Forefront requests that the Commission allow it to subscribe up to 650 subscribers per each of its community solar systems. Forefront is in the process of developing 6 community solar facilities, 2 in BGE's service territory, 2 in PEPCO's service territory, and 2 in Delmarva's territory. Applicants' focus is residential customers, including renters and low to moderate income households. Initial marketing efforts indicate that given the load of these residential customers and indications that the customers will enroll for less than 100% of their historical usage, it may be difficult to fully subscribe a 2-megawatt community solar facility, which is what each of theirs are, I believe, with 350 subscriptions, which is what the regulations call for. Consequently, Forefront asks that the enrollment cap be lifted to 650 for its facilities. Under Comar 620203, a subscriber organization may subscribe up to 350 accounts for CGIS unless the electric company is in the project's service territory has developed an automated billing function for the program. If the electric company serving the community solar facility has developed an automated billing function for the program, a subscriber organization may subscribe as many accounts as needed to match the capacity of its facility. The regulations do not require the development of an automated system. Staff has contacted BGE, Pepco, DPL, and the Potomac Edison Company regarding the ability of each to handle applicants' request. BGE, Pepco, and Delmarva, where Forefront's facilities are located, or will be located, indicated that they could comply with Forefront's need for an increased cap. Staff recommends that the Commission waive Comar 20-620203A for Forefront Power LLC and allow applicant to subscribe up to 650 subscribers in each of its facilities.
Great, thank you. Are there any questions for staff? Commissioner Herman?
So are we talking about doing this for a facility in PE service territory?
No.
No, okay, so we don't have to worry because that PE can't do it. I didn't think so, I just wanted to, because you mentioned talking to PE, and I wanted to make sure that we were
I didn't want to
clear.
leave them out, but
Oh, okay.
you're correct. They said they can't do it.
They said they can't do it, but they don't need to do it, so we don't have to worry about it.
Let me ask the question here. Are there any other of these type of waivers in the queue?
The 350 waiver. I got one, I think, earlier this week, and it is for a number of facilities. I asked BGE if they would be able to, I think Mr. Person's still here, yeah. So if they'd be able to handle this for all comers, and BGE said yes. I asked PHI, but I have not heard back from them yet, so I hope to hear back next week.
I guess a general concern that's sticking in my mind, and I'm interested to hear from BG&E as well as Mr. Green, that this is the new flavor of waiver coming with CSEGs. And if it is, what is the cost to the utilities? And Mr. Herson may be able to give me a sense of that. They're implementing these new billing systems. Or is that a cost to the ratepayers, additional cost that wasn't anticipated? Give me a sense of that, somebody.
Yeah, I think Mr. Herson may have to answer that because the regulations do not require that this be done by the utility for the purposes of the pilot program.
Good morning, Commissioners. Daniel Herson for BGE. So, Commissioner O'Donnell, the concern isn't added cost. The concern for us is our ability to process these. Until that automated billing system is put in place, we're going to have to do this work manually. Now, we didn't object to this request, and we can handle this one, but I would be lying to you if I didn't tell you we have some concerns about what I feel is a pending flood of these requests coming in. We've seen some other ones filed, and I'm not in a position to say that we could handle one company's but not the others. I don't think that would be fair to the developers, but we do have some concerns about our ability to actually do this work until that system is put into place, and that's not going to happen by the end of this year. I think right now we're looking at a first quarter of 2019, perhaps getting that system put into place. So again, we don't object to this, but I think we share your concerns about this pending wave of these requests and our ability to actually get this done. Once the system's up and running, I don't think it's going to be a problem, but until that happens, it could have some issues.
Was that automated billing system for CSEGs going to happen regardless of, in other words, is it an unanticipated expense associated with CSEGs? For the utilities.
I'm not sure the genesis of the commitment to put the system in place. We were going to do that system because we did not want to have to do all of this manually.
But it's being done for the community solar
that's correct.
pilot specifically.
Yeah, that's correct.
Okay.
So I don't know that my remarks are really helpful to you. I'm just telling you the reality of the situation right now is that we have a lot of work to do, and I'm concerned about all of these requests coming down the pipe.
Well, I can only speak for myself. I find your response very helpful. We have one utility who has said they can't do it. We have another utility now, the biggest utility, saying we have concerns. I think it would probably be fair to hear from Mr. Green.
Thank you. Any other questions? Great. Mr. Green, I presume you're here for the company?
Brian Green for Forefront. Just to follow up on that conversation, we have spoken with the PHI companies several times. They do not object to this request, and I think the reason is because that and we put this in our comments, they're already doing this kind of billing in DC with their community solar projects there, so they're able to handle it. So, although they don't have a Maryland automated billing functionality under the COMAR, but they can handle this request, and they do not oppose it. With respect to BGE and with PHI, but especially with BGE, based on what we just heard, the Forefront projects aren't coming online in the first quarter of 2019, at least not before that. So to the extent that they aren't online, we need the certainty to be able to go out and fill these projects, to know that the cap's not there, but then either when they come online or very shortly thereafter, there'll be an automated billing function in place from BGE, and the cap won't matter anymore. So it's really, most of this request, hopefully, is about the certainty of being able to fill up the subscriber bucket so that when it is operational, there'll be an automated system in place, and then the cap won't apply, if that makes sense. So, and we think that's going to be the case with most, if not all, perhaps, of the Forefront projects. But this is also in line with the lifting of the cap, would be in line with the General Assembly's intent behind this statute, which was to bring more broad ownership into solar generating systems, allow these systems available to renters, low and moderate income families, and that's what this does, because it increases the number of participants in the programs. So unfortunately, it means added manual billing perhaps for the utilities, but they don't oppose this request. And I understand that there's others that have been filed. I don't usually like a race to the commission and to say that we're first, so I'm not going to advance that argument. But hopefully, by the time things are actually operational, and to satisfy BGE's concern, they will have that system in place. Initially, when we filed this, we were advised by BGE that they anticipated having an automated billing system in place by the end of 2018. They wouldn't commit to it, nor would we expect them to. And now, obviously, that's been moved back, and I think they're saying, and Mr. Hersham may have just said this, the first quarter of 2019. So hopefully we're getting there with BGE.
Mr. Green, remind me again why you need 650 instead of 350. Tell me the specifics of that.
Right. So there's two things that kind of play on each other. I think the first is that the potential subscribers to the project so far for Forefront, by and large, have been lower than average household users compared to 2016 Maryland state data. And then on top of that, they're subscribing for 80% of their historical usage, not 100% or more. So they're using less and subscribing for 80%. So that means you got to have more users enrolled.
So you need more load to use up all your capacity.
Right. So it's actually a good problem to have. I understand the burden it puts on utilities, but what it means is that more people hopefully can participate in the program from the beginning.
In the stakeholder process and work groups for community solar, I think the stakeholders came to a consensus on this cap, but should we be concerned about setting precedent here? And you gave so-and-so a waiver, now we all need a waiver, and the burden that puts on our utilities. I mean, we got one utility saying outright they can't do it. We got another utility who has expressed here today some concern about that.
Well, I mean, I think with respect to Potomac Edison, Forefront has 2 projects in Delmarva, 2 in BGE, and 2 in PEPCO. So we're not, that just doesn't come into play.
But I'm talking about the precedential nature of this and the continuing
No, I understand.
waivers.
I understand the concern. I think the question is down the road, is this a problem for Delmarva and PEPCO? I'm not aware, I don't know one way or the other, if they got to a certain number, whether it would be a problem. Because like I said, we were advised that they're already doing something similar in DC with their systems there. So with respect to BGE, like I said, hopefully they'll have their system up in the first quarter of 2019, and then because of the wave of all the extension requests, then when the operational dates come in, they'll be ready to go, and there won't be the problem that we're afraid of.
Thank you. Are there any other questions for this item? Great. Yeah, I also want to join Commissioner O'Donnell in thanking the company for their support on this request, and I think it will be important for the overall success of the pilot that we can make this accommodation. So, with that, is there a motion?
Yes, Mr. Chairman, and I'll note that this motion is with respect to this fax and this situation only, that the companies at issue have agreed that they can accommodate it in this situation. So I want to be very clear about that, and to the anyone else who might be listening, that it may not always be the case that this waiver can be granted. So I want that to be clear. So, Mr. Chairman, I move that we grant the requested waiver of COMAR 20-62023A for Forefront Power LLC and allow the applicant to subscribe up to 650 subscribers in each of its facilities.
Thank you. Is there a second?
Second, and on further discussion, I will also express my intention that my vote in favor of this is specific to this case, and I do not consider it precedential and will not bind myself to future votes of a similar nature. Second.
All in favor?
Aye.
Opposed? Motion carries.
The last item on the agenda is item 13, Forefront Power LLC, filed on September 14, 2018, request for waiver of operational deadline Snow Hill project.
So this is your last waiver of the day. Forefront Power
Thank goodness.
is seeking a waiver for one of its facilities in the Delmarva service territory. Forefront is asking the Commission to waive COMAR 20-620304C by extending the 18-month deadline for 7 months after the operation deadline for completing a community solar energy generating system. As good cause, which is required under COMAR 20-620104 for granting this waiver, applicant notes a period of various delays in the local permitting process, including an unanticipated highway expansion project requiring certain changes in Forefront's original plans. According to Forefront, the permitting process for the Delmarva project is not expected to be completed until this fall. Applicant states that construction will take 120 days and cannot begin until April after the possibility of adverse winter conditions have passed. Relying on information provided in Forefront's September 14, 2018 letter, staff recommends that the Commission, consistent with its previous rulings, extend applicant's operation deadline to June 1, 2019. This provides Forefront approximately 4 months additional time in which to build, or 22 months in total, for meeting its operation deadline. Applicant has outlined a scenario under which an extension beyond June 1 may be justified. Should additional time be needed, applicant may request an extension of this waiver in May 2019.
Great, thank you. Are there any questions for staff? Hearing none. Mr. Green, you're here again, I guess, for Forefront.
Good morning, Brian Green for Forefront. So we're asking for an extension through September 7th, and the reason here, as you talked on the earlier admin agenda, each application has its own situations and circumstances, and what happened here was that Forefront had a site plan approved, had finalized its stormwater and environmental plans, its forest conservation banking requirements have been met, and then Worcester County came in and had an unexpected highway extension project, which caused Forefront to have to redesign the project with respect to the entrance and access road, and had to redo all of the stormwater and environmental plans, and also to make significant changes to the forest conservation banking requirements. And that, as we said in our comments, was about a 3-month delay. That was not something that anyone from Forefront could have foreseen coming. We think now that they have all of the permits in place, and the next step would be the building permits. It is going to take a couple more weeks, they think, to get the landowner's signature on the forest conservation banking documents. But within another 6 weeks, at most, hopefully, will be the building permits, and again, that puts us, right into December. So, the problem with the weather-related construction, to dig a little deeper, is that you get into electrical trenching, where we're advised that you need compaction of the soil when you put the dirt back into the soil. Moving cold or frozen, rather, dirt is not very compacting. And then also you pile drive the holes, which is very difficult to do in the January-February time period. There's also additional utility work that needs to be done. We're advised that the utility can do that in mid-January. This is Delmarva, by the way. So ideally, we're told that the trenching and the pile driving can begin at the earliest in late March. So we've said April 1st and gone from there, and that got us to, with 120 days that we've been consistently told for the construction on our projects, puts us into early September. So we've asked for September 7th. Staff has said June 1st. That's just, the closer you get to June 1st or even earlier, the higher the likelihood is that we're going to be back here. And you're taking what we've consistently been told from our contractors on our projects as 120 days of construction and having that, which is going to be dependent on everything going not just smoothly, but twice as smoothly. So we don't think June 1st is doable. The last project when we were in here, the commission went with September 1st based on a moratorium. This is not exactly identical, but it has some similarities in that Forefront had everything on target, and then things beyond its control set it back. So we would suggest September 1st as the extension date.
Similar to the earlier discussion, so if you can begin construction in April and you need 120 days, would July 30th be a good tailored date for this
we
project?
Had added in, you're right, we had added in an extra 30 days to the 120 to get us to September, with the idea that if something goes wrong or if we can't get the subscribers, we'll have the time to make that up and we won't have to come back in here. I think if we wanted to go, whether it's August 1st or July 30th, the company could do that, but we're really nervous about going any earlier than that. So and that's why we would prefer the September 1st date.
Okay, and the reason I'm suggesting that is your own timing. You say 120 days, so as you can see, there's not a lot of tolerance for too much time here.
I certainly feel the vibe.
Yes. Just using the information you provided, that would take us, is that correct, to July 30th?
Yes.
Okay, thank you. Are there any other questions? All right, any discussion? I would, again, propose that we alter the proposed motion to July 30th. So that would be my suggestion.
Without belaboring the point, Mr. Chairman, I still maintain that construction goes on all the time, including pile driving and trenching in winter months. May not be easy, but it happens, and these are commitments made by these developers under the auspices of the program, and I'm not buying that we have to wait until the rainy season of April when the daffodils and crocuses are already out of the ground before we can start construction. I will be voting no and supporting the staff's recommendation.
Okay. Commissioner Herman, do you have anything you want to add on before we entertain a motion?
No, I'm comfortable with July 30th.
Okay. Commissioner Linton?
I'd agree. July 30th is fine.
Okay. Commissioner O'Donnell,
I'll defer to Commissioner Linton if you would mind making the motion.
Very good. Thank you. Commissioner Linton, is there a motion?
Yes, Mr. Chairman. I'd move that we grant Forefront Power LLC a time-limited waiver of COMAR 20.62.03.04 C2 from February 7th 2019 to July 30th, 2019.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Thank you. The motion carries. With that, we are adjourned.